Okay, welcome back. Okay, our next panel is a really interesting one on some of the most kind of pressing and interesting SEC priorities right now, including SPACs, ESG, cybersecurity, and we have a terrific panel. Let me start by introducing Kelly Gibson. Kelly is a partner at Morgan Lewis based in New York and co-leader of the firm's securities enforcement practice. She previously held several roles at the SEC, including the acting Deputy Director of the Division of Enforcement. She was the leader of the Enforcement Division's new Climate and ESG Task Force and Director of the Philadelphia office. Welcome, Kelly. Michael Maloney is a Senior Managing Director at FTI, based in Washington, D.C. He has a really interesting background and great experience. He was previously the Chief Accountant in the SEC's Division of Enforcement, also president of Credibility International, a forensic accounting firm. Welcome, Michael. Dan O'Connor is a partner at Ropes & Gray in Boston. He co-leads the firm's securities and futures enforcement practice. Prior to rejoining Ropes & Gray in 2008, Dan was a senior trial counsel at the SEC and previously a watch officer and assistant engineer aboard the nuclear-powered ballistic missile submarine, the USS George Bancroft. Excellent. Welcome, Dan. Welcome to Carolyn Welshhans, Associate Director in the SEC's Division of Enforcement. She conducts and supervises numerous investigations in insider trading, market structure, financial fraud, market manipulation, hacking, and she received her BA from the College of William & Mary, so shout out to my fellow William & Mary alumni. Finally, pleased to welcome Anita Bandy, our moderator. She is a partner at Skadden in Washington, D.C. as of March of this year, if I'm not mistaken. But of course, prior to joining Skadden, Anita served for 17 years at the SEC's Enforcement Division, where she held a number of leadership roles, including being an associate director. Anita?
Thanks so much, Bruce, and thank you for organizing this great conference that's much anticipated every year. It's great to be here in person, and I'm really excited to be here with this panel. The panel includes individuals that are thought leaders in the areas that we're going to be talking about today, which include the SEC's highly active rulemaking agenda. We hope to cover SPACs, ESG, cybersecurity, and beyond, both in terms of what these rulemakings mean, its impact, its anticipated impact in the public issuer as well as the registered space, as well as how enforcement's using its existing authority even before these rulemakings are finalized. So in fiscal year 2022, we saw the SEC continue to pursue a very consequential rulemaking agenda that impacts just about every corner of the market in areas of SPACs, 10b5-1 plans, private funds, cybersecurity, just to name a few. Many have argued that these rulemakings go too far in being too costly, too prescriptive, which hurts capital markets, while others have argued that these rulemakings are addressing much needed investor-focused protection in these areas. While we await Commission guidance in terms of what form these rulemakings are going to take, one thing is very clear, that the Division of Enforcement is using its existing authority to pursue these high priority areas and send its message. So let's start with ESG. This is an area that covers a lot of ground and can mean a lot of different things. The S&G part of ESG can mean board diversity. It can mean the Me Too issues emanating that can hit the proxy statements, human capital management, among other areas. And this last proxy season saw a rise in requests for racial equity audits by a lot of activist shareholders. But the most controversial aspect of ESG is really the E part of it, which is focused on climate. That part of it remains high priority, although it's unclear in terms of whether the Commission's going to meet its anticipated goals of a year-end finalization, given the fact that the rulemaking has recently been extended, and then there's the West Virginia versus EPA case that may curtail some of the authority on that part of the rulemaking. So Carolyn, look, unclear whether the SEC is going to scale back, but enforcement's really moved on in terms of filing some very important message cases. Would love to hear your perspective on key takeaways and how enforcement is looking at the climate aspects of ESG.
Sure, and before I give that perspective, I have to give the disclaimer, which is that the views I express here today are my own and not necessarily those of the commission, the commissioners, or the commission staff. So in terms of the way enforcement's been looking at climate in particular, as you noted, that has gotten a lot of attention. I think the first thing I'd say is that, the SEC is very focused on what matters to investors. And you just went through, a number of issues that are not just in the news, but have been talked about increasingly by investors. And the SEC is first and foremost a disclosure agency. So that's the principle that enforcement starts with. We look at what is the information that is being given to investors. Is it material? Is it accurate? Are there omissions? That in and of itself is not a new approach. We've applied that approach to other issues that over time have become material to investors, and climate is the latest one, and certainly one of the ones that, as we've all noted, has been talked about very heavily. So we've seen this in the public company space, we've seen it in the advisory space, where there have been cases that come down to the disclosures. They come down to if a company or a regulated entity chooses to speak to investors or clients about climate, they have to do so in a way that is not materially misleading. In Valet, which was a case against a public company, for example, the SEC charged materially misleading statements. In BNY Mellon, in the advisory space, similarly charged misleading statements. One of the things I think that's interesting is that where we see the omissions. So it's not just, are you affirmatively saying something that's materially misleading, but again, if you choose to speak about climate, choose to highlight it for investors or clients, are you omitting information, material information, that thereby creates a misleading impression about what you are or not doing in that space?
So you mentioned disclosures and the principle-based approach. So the proposed rulemaking seems to take a more prescriptive approach in mandating certain disclosures regardless of the traditional concepts of principle-based disclosure, whether there's an impact to stock price or financial performance. How, what's your take on that in terms of the rulemaking and how enforcement currently, with its current authority, is thinking through issues of materiality in reviewing this space, both as it applies to issuers as well as the regulated area?
No, I think it's a really interesting and important question, and I would imagine one that's very important to the defense bar when advising clients. So interested in what my colleagues have to say about this. I'm not going to speak about the specific rules because they're in various stages in terms of the comment process and things of that nature. But from an enforcement perspective, exactly what you said, Anita, it's not just quantitative. It's not just does something impact the bottom line. That is obviously very important if it does, and I think is the easier materiality standard to get to if something is quantitatively material. But there can be other ways that information can be material to a business. And some of the guidance around the rules in the proposals, whether it has to do with ESG or other aspects of the SEC rulemaking, get to that concept that something can be material to a company, for example, specific to that company's business or its operations, not just its financial statements. And so I think you have to look at the particular facts and circumstances of that company or that advisor. For example, if we're talking about the fund space, is it something that gets to how that business operates that makes it material? Does it get to the products of the company? Things of that nature. If the company has really put a lot of emphasis on its marketing around, for example, what it's doing in the climate space. Those are ways that I think it can become material, even if you don't necessarily see that translate to the bottom line.
You also mentioned the Valet case, which is a very seminal filing in this area. Now, what's notable is that case did not include books and records controls charges, which is not atypical, for disclosure-based cases. But with the new proposed rulemaking, there is a litany of controls, governance protocols that would need to be implemented. And so I'm wondering if you could talk again about the existing authority, not necessarily anything that's in the proposed rulemaking that we're awaiting commission guidance on, but in terms of existing authority, how is enforcement looking at books and records and controls violations as it applies to the ESG disclosure space?
You're absolutely right. I mean, there can be implications there. And again, you've heard this on every panel. You're going to hear it a lot from me today. It depends on the facts and circumstances of a particular case. And I'm not going to speak about any charging decisions in any one case. But you can have a situation where if what you're dealing with is a disclosure issue, for example, there may be questions around the disclosure controls or the financial reporting. If it is something that is getting to the accounting, you could have issues with the internal accounting controls provisions, for example. So there are lots of different ways that different provisions could be implicated. That's not unique to climate. We see that in financial and accounting cases all the time. And it's just, comes down to what happened, how were things handled, what was the process within the company, et cetera, to get to what are the appropriate provisions to charge, what are the appropriate ones to highlight in any given case.
That's really helpful. So Kelly, turning to you, in March 2021, the SEC created a climate and ESG task force within the enforcement division, whose mandate it is to develop initiatives to proactively identify ESG-related misconduct. And then we also know that exams have made ESG a high priority area in terms of its authority. Can you talk through risk factors that increase the likelihood of enforcement opening on a matter and other perspective on how best to manage these risks as registrants, both on the public issuer side as well as the regulated side, tries to come into compliance with the rulemaking?
Sure, and let me just start by following up on a point that Carolyn made, because I think it's important to keep in mind, and that's the concept of materiality. And I think both from my time being at the SEC leading the ESG task force and now being on the other side of the table, I think from the SEC's perspective, if you're making a statement about ESG, the SEC is going to consider it to be material. And I know we'll talk more about that, and I know that's a blanket generalization, but at least from what I'm seeing, that's not the point to argue with the SEC. And so I just make that point because it sort of serves as a backdrop to a lot of what we're talking about here. And the biggest risks, I think, whether you're a public company or you're a registered advisor or fund, and that's you're doing what you say you're doing. And that overall, whether there are new rules in place or existing authority, that's the most important thing to consider. And that's, misstatements are probably the easiest thing for the SEC to charge. And so from that perspective, you have to make sure, as Carolyn said, your statements about ESG are accurate, they're consistent across the board, and they're verifiable. You have to be able to show your work. And we're seeing that a lot on the defense side, not just on enforcement and investigations, but also on the examination side when Division of Exams is going in and they're making requests of investment advisors and funds, they're asking for you to show your work and show that what you're saying is happening. And so while I wouldn't necessarily advise clients to do everything the proposed rules are saying to do because we don't know what the final rules are going to look like, there are some best practices you can do now to start considering where you lie in terms of what the proposed rulemaking looks like, and then just some general best practices. I think the first thing, if you look at the proposed rules, and we can start with registered investment advisors and funds. If you look at the proposed rules, as you all probably know, there are 3 categories of strategies that you can fall into. There's integration, if you consider ESG as part of your strategy. There's ESG focused, if it's the main consideration, or ESG impact funds, and that's where you're seeking to achieve a particular ESG impact goal. And so you can start to assess where you lie within those categories, and then figure out, what your current disclosures look like with regard to what the proposed rules require for each of those categories, and then look at your policies and procedures against your investment practices to make sure that they all align. And again, I think because the SEC views materiality through this broad lens, it's important to be careful of the language that you're using in these disclosures. And so, especially where you're making pronouncements that are like of a definitive or categorical nature, these are things that we're really seeing the SEC drill down on, both on the investigative side, but also on the examination side. And I think that's a good example of the case that Carolyn mentioned with BNY. Also be aware of terms like green or sustainable might raise greenwashing concerns. So it's good to internally define your ESG statements before going out and putting them out for the public to see, so that you can say to the SEC why you think those statements are warranted. And then to make sure that, any kind of language you're using, whether it's in investor presentation slides or, responses to RFPs, RFIs, due diligence questionnaires, all of that information is accurate and consistent, and that your policies and procedures are all aligned with regard to those statements. And then on the public company side, again, it's important to make sure that your statements are accurate and that you can show your work. But to make a point with the Valet case, it's important to keep in mind that voluntary statements also need to be true, consistent, and accurate. So, for example, corporate sustainability reports, statements on your company's website, all of those are going to be checked and scrutinized by the SEC too. But the proposed rules, as you mentioned, Anita, they're very prescriptive on both the investment advisor and public company side. And so there's a lot of information the SEC is requesting, which means there's a lot of information they can scrutinize. I think on the public company side, the most controversial, and we'll see how the rules play out, is probably with regard to Scope 3 emissions, which is your indirect emissions up and down the value chain, because that information can be so hard to collect, it can be inherently unreliable, and hard to assess materiality. So we'll see how that plays out. In the meantime, I think, looking at your corporate governance structure and making sure that you have the proper oversight with regard to your risks for your operations, that all of that is in place. Make sure that you identify any high-risk areas, especially with regard to climate-related goals and transition plans. And then review your existing climate-related disclosures to make sure that you have, the consistent plan and communications across your organization to verify that they're accurate.
That's great. Thanks, Kelly. So we just talked about disclosure. Now pivoting on the accounting side of the house, as we've all read in the rulemaking, there's a 1% threshold for climate-related financial disclosures, which is really well below the SAB 99 way of how we're used to thinking about issues of materiality. And companies would have both qualitative and quantitative reporting obligations. So Mike, could you unpack this for us, and talk through what are the line items and accounts that companies should be most worried about if this 1% threshold ends up becoming a part of the final rulemaking?
Yeah, so I think it's a really unique part, even though we're not here to completely unpack these proposed rules. It's really unique from an accounting standpoint to have a potential requirement that goes line item by line item in the financial statements. And I think it also underscores for me the significant change both in internal controls. All this information would need to be audited and so forth. So this is really would be a sea change if it goes through. Yeah, and I think you've kind of hit on it. I mean, we've talked about materiality and in SAB 99, which relates to the financial statements, as most people in this room know. It's really interesting because SAB 99 specifically discourages and says you should not use quantitative rules of thumb, even though it talks about 5%. And it says it's the total mix. It essentially follows the Supreme Court definition. So that really could create real conflict with how these issues get assessed. And you're going line item by line item, and if it's over 1%, you need to disclose the impact separately, positive and negative. And so I think that's going to create enormous challenges. Just flipping through the enormous number of comment letters that have come back on that particular issue, you see real themes in there. One is this issue of SAB 99 kind of works differently, and this is a new concept on materiality in this space. One said, many comments about that 1% disclosure being too low, and it could lead to both the under-disclosure or over-disclosure of information. I also thought there was, costly implementation. There's a lot of comments about that, but also you think about it from the auditor's perspective. There were comments from audit firms saying that auditors devise their audits based on different types of materiality scopes. And adding this in could be wildly inconsistent with how the auditors would approach the audit, which could lead to a lot of inefficiencies in the audit. So very controversial, I think, if it goes through. On the line item side, one of the things I think, and actually it relates to cyber as well, which is maybe one of the topics we talk about, lost revenues are a concept that comes from a severe weather event. And quantifying lost revenues, I know in the cyber world can be a difficult thing. So that's an area right off the bat. Like, how do you quantify that? And how quickly can you quantify how much revenue you lost from an event? Expenses may be easier to do if you go down the expenses, because that's more about what did you actually incur related to an issue. But what did you really lose? What's not there? I think that could be harder. And then finally, on the balance sheet, it talks about impairment issues. Do these types of events trigger impairments? Well, lots of things can trigger impairments, lots of business issues. And so how direct is the line of a weather event to whether or not that triggers an impairment? So there's a lot to unpack there, but I think it's going to be extremely challenging if it goes through in that manner.
Yep. No, all fair points. So before we move to SPAC, just really quick, Dan, I'm just going to ask you about green bond principles and underwriters. We've seen enforcement pursue a case against a fairly large public issuer. There's been a case in the registered space. We haven't seen anything focused on underwriters or issuers that are raising funds through green bond principles or bonds that are green. Do you think that's the next frontier? Is that an additional area of focus we can expect coming out of enforcement?
I wouldn't be surprised by that. I think the municipal bond area is, and that unit likes to bring cases against other than schools and, municipal folks that are otherwise, have real jobs. I think that's a place that the underwriters, it could be a place that's a focus there. I think in the rule space, it could be a space that the EU is already making noise in that regard. So I think that's something that we could see in the near term. Definitely something that's coming up.
Great. We'll have to wait and see what fiscal year 2023 has in store. So moving to our next topic area, which is SPACs. Even before the rulemaking has gone into effect, the proposal has largely had a significant chilling impact on the market, given the possibility of underwriter liability attaching to banks advising on these deals. We've already observed several banks file 11B letters resigning as advisors on these deals and expect more to come. There's also a requirement for issuers to obtain a fairness opinion, which could make SPACs more costly and burdensome than what traditional IPOs require. So a lot going on in that space. Dan, let me stay with you and get your thoughts on the rulemaking. In your view, do you think the rulemaking is reactionary, that's managing to the worst one-off conduct? Or is it a reasonably fair way to impose some discipline in a high-risk area of capital markets that's impacting retail investors? Would love your thoughts on whether it goes too far or what the right balance should be in terms of enforcement authority.
Well, I think there's a mix there. There obviously are a lot of aspects of the rules with respect to disclosures, things like that I think, codify what a lot of the practitioners, what a lot of the issuers in the space are already doing with respect to conflicts, things like that. I think some of the cases that have already come out are going after some of the worst practices. And it's not as if there hasn't been enforcement in this space without these rules, investigations that are going on without these rules. But I do think that there are aspects of the rules, and the comments here are pretty extensive, and I think significantly tilted against modifying and cutting back on certain of the rules, having spent a lot of time over the last few weeks getting ready for the panel, looking and wading through the comment letters in certain of the places. While there are some significant support here, right? And it focuses down a lot of it on your perspective, right? What is the nature of the rules here? Is it investor protection, or is it promotion of capital? I think the ABA letter lays out in pretty nice respects. There's 4 ways to get into the market for a private firm to access the capital markets. You can do an IPO, a direct listing, an M&A transaction, or a de-SPAC. And what we see from the industry groups, from the law firms that are in the space, is that, as you mentioned, these rules, without even really coming into effect, they've just put a huge chilling. And that's on top of a lot of the rulemaking by pronouncement that has already happened around the restatements and other things that have taken place, some of the work that's going on with CorpFin when people are trying to go in and get proxies approved and things like that. And there's 2 principal things that I think that have really been a focus of the comments. The rules with respect to the definition of underwriters, and then secondly, one of the big issues that's gotten a lot of attention is the safe harbor under the Investment Company Act. Starting first with the issue as it relates to the definition of underwriters, right? So there's already a definition of underwriters in the Act itself, in the 33 Act. Basically any person who has purchased from an issuer with a view to offer or sells for an issuer in connection with the distribution of any security, or participates or has a direct or indirect participation in such undertaking, right? What we think of as a typical underwriter, someone who buys securities for an issuer for the purposes of reselling. That's, gives rise to Section 11 liability, which is a huge hammer that is used in class actions and really puts a lot of focus on the diligence work that underwriters do, not a lot of attention per se in the enforcement world where we live. But what this new rule is doing is seeks to significantly expand that. Very clearly, very explicitly. Notes that any person who has acted as an underwriter in the SPAC IPO and takes steps to facilitate the de-SPAC transaction or any related financing transaction or otherwise participates in the de-SPAC shall be deemed to be an underwriter under Section 11. So it really links the de-SPAC transaction with the initial SPAC IPO, and that's what's led to the letters that you mentioned, where the banks that were in the initial IPO have just stepped away. And you talk to the practitioners in the space, and they say this has really put a chilling fact in there. And what the letters talk about this, the ABA letter, the SIFMA letter, a number of the letters that have been submitted by the law firms in the space, is that it's just a misunderstanding of the nature, in some respects, of the de-SPAC transaction, in that it is not a transaction that has underwriting activity taking place in it. The fact that there might be financing activity, the fact that there might be involvement by someone who was an underwriter in the de-SPAC up front, they're not going to be providing that activity. And I think some of the comments that have come out, I think will perhaps cause some changes in the rules. And I think, there was some mention earlier of the West Virginia v. EPA case. I think that might provide some basis for some thoughts here. There's obviously the Chevron typical issue with respect to rulemaking concepts and the ability to kind of really expand the nature of that definition, which has been in the securities rules for almost 80 years, significant attention by the courts in terms of how that expansion is going to live with underwritings. And where there already are cases in terms of the enforcement side that have looked at the diligence activities, and enforcement has that ability to look at who is conducting the diligence activity. There was a case in 2019 against Gordon. Now, someone involved on the SPAC side, but we all know the enforcement team can look at the issues and bring in people with causing type activities and bring in someone who might actually really be involved or have potential actual
You mean
activity.
as opposed to going after statutory underwriters using secondary liability or tools that already exist? So that's a really good, I think, segue to get Carolyn's perspective on enforcement using its existing authority to send a very strong message in this space. We've seen enforcement not shy away in terms of litigating these cases or going after individuals. Let's leave underwriters aside, but I would love to get your thoughts there because we haven't seen the SEC pursue statutory underwriter liability in this space yet. Would be curious as to what your views are. in that going forward. But in terms of the cases filed to date, what are the takeaways? What is the message that enforcement is sending in this space using its existing authority?
Sure. As Dan noted, we have filed cases in this space. And I think that the takeaway for me is, I think about SPACs as, they're the latest sort of financial product transaction, however you sort of want to think about them loosely. And that's, to me, one of the beauties of the securities laws, that they're adaptable. It's why I don't find this space boring, and I've stayed in this area for my whole career. We have these statutes that have been around since the 30s. They've been able to adapt for M&A, for reverse mergers, SPACs, IPOs, whatever it might be, because they come back to certain principles. Dave Hirsch talked earlier about the importance of registration. We also have the principles of disclosure. So I think one of the takeaways in this space is that we've been able to bring these cases. We'll continue to look where, in particular, we see retail investors going, and that's one of the things that's really been marketed about SPACs, that they're so great for retail investors. So we're going to look really carefully at what are the disclosures. And unfortunately, we have seen issues at every stage in the process. We've brought cases against the sponsors, against the target companies, against individuals, against the eventual de-SPACed entity, because there can be different sets of statements that are made to investors, as I said, at each stage, that can be problematic. And so unfortunately, I think we'll continue to see cases involving those entities. We're interested in conflicts of interest as well, not just what are investors being promised in terms of what's going to happen with their money, but also are there conflicts of interest by the various players that have not been disclosed. Again, that's not unique to just the SPAC area. We see that with other sorts of financial transactions, but that's where you've seen us use our authority. It's, I think, where you can expect to continue to see it.
And what about just really quick, 30-second takeaway on underwriters? How is enforcement looking at putting the rule aside, in terms of what are the risks for underwriters in this space from an enforcement perspective?
Yeah, and again, I don't want to talk about anything that may or may not be subject of an investigation, and even as I thought David said it very well, even the fact that there may not be any investigations in this space. So let's take a step back. Again, not unique to the SPAC space. When it comes to underwriters, I think one of the primary concerns is that conflict of interest. Are they wearing multiple hats that cause them to not have the financial interests that they're supposed to have at heart, and instead are bleeding over into self-interest? And is that being disclosed to investors? That's one thing that comes to mind when I think about underwriters, and again, not unique to this specific space.
That's really helpful. Thanks, Carolyn. So Mike, really quickly, warrants and SPACs. We saw a lot of guidance coming out of OCA on warrant classification, which led to a domino effect of restatements across many industries in terms of how SPACs have been accounting for warrants. So what can you tell us in terms of how companies should be thinking about accounting for warrants?
Yeah, I think so. As Anita said, April 2021, CorpFin and OCA put out a joint statement about warrant accounting, and essentially it changes a classification on a balance sheet between equity and warrants, which is debt. And so it's a really complex area. I don't think we've seen this play out yet. There were hundreds of restatements because there was so much SPAC activity in that time period. It affected almost all SPACs. It is just a balance sheet, but if it's a warrant issue, if it ends up being a warrant, you also have to fair value that warrant, and any changes in that fair value goes through the income statement. So it's super complex, and that's where I think the interesting question is. In my own personal experience on some cases, I've started to hear some questions from the staff about the issue. I think maybe common knowledge or common view might be that, it's complex and maybe the rules changed, maybe they didn't, but it was new guidance, and so hopefully enforcement won't be coming hard after people on this issue. But I think it's kind of stay tuned to see whether enforcement goes hard. Or one last thing I'll say is opens up an investigation on that issue, but then it expands into other areas.
Yeah. So moving to our third topic, cybersecurity. Again, a common theme of today's discussion, enforcement's certainly been active using its existing authority. One issue that I've certainly gotten a lot of questions on since I left government is this tension between the proposed rulemaking and the 4-day reporting period from the discovery of a material breach or a material incident, and the lack of an exception for the impact of the disclosure may have if a company's cooperating with other law enforcement, if there's a national security interest or there's an FBI investigation, as the current structure stands, as well as under the proposed rulemaking, there is no exception for that. So Carolyn, would be really helpful to hear how enforcement is factoring in or reconciling these sort of competing duties to regulators when thinking about a disclosure obligation and also balancing out, the scenario where public company has disclosure obligations but is also a victim in these types of scenarios.
Sure. Well, first of all, we can't have regulatory arbitrage. So we have had situations where companies who have experienced cybersecurity incidents have told us that we should not move forward because they are talking to other authorities, particularly criminal authorities, who do not want us looking at something. Or have told us there's nothing to see here. The criminal authorities, have already blessed this, that there was nothing interesting here, so SEC, you should go away. And then we talk to the criminal authorities, and it turns out that is not the case. They have not said that they have a problem with us looking at it, or it may turn out that we have information that the other authorities don't have that now they're interested in. So, I'm wary of that happening going forward, and we look out for that. We know how to talk to our partners in the criminal authority space as well as other regulators and internationally. If it is a situation where there truly is a national security concern, or the criminal authorities, for example, truly have a concern about us doing something that would disrupt an ongoing covert investigation, we know how to handle that. We handle that in the cybersecurity space. We handle it in other spaces. We know how to be good partners with law enforcement. What I would advise against is not telling us, because we're going to find out about the security incident regardless, whether it's through the whistleblower, whether it's through somebody going to the press, whether it's through the criminal authorities or the National Security Division or somebody else coming to talk to us because they're interested in our thoughts and our expertise. So give us the benefit of giving us the information, hearing your side of the story, and then letting us work with our partners to figure out what happened and what's the best path forward. We handle a lot of cybersecurity investigations. There have certainly been some cases in this space. There will definitely be more, but the vast majority, we take a look, we understand what happened, and we exercise our discretion in understanding that companies can be victims, and that it doesn't necessarily translate to a securities law violation just because there's a cybersecurity incident. We know everybody experiences them.
So we talked about disclosure obligations. The new rulemaking, the proposed rulemaking, also includes a host of corporate governance and disclosure controls obligations. And that's an area where enforcement has brought at least one case, the first American case, where a vulnerability behind a breach wasn't even exploited, but that case was charged under disclosure controls because there was a lapse in terms of the company taking a holistic approach and having controls where from the bottom all the way to the board, there was no alleged protocol by which that information was being communicated. So Kelly, I wanted to turn to you. In light of the first American case, as well as a sweep under Reg SP that the Commission pursued in the regulated area, how should registrants be thinking about controls surrounding cybersecurity risk from the bottom all the way to the top?
Yeah, and I think this is a really important consideration. And I think with that 4-day time frame, a prompt materiality assessment is going to be critical, and disclosure of that issue. And so you need to have the proper procedures and controls in place to make sure that you can conduct that assessment. But to do that, you have to have the right reporting structure in place. And so you also have to have robust controls and procedures around reporting from the bottom all the way up. So as in First American, for example, they alleged that the IT personnel had learned of the vulnerability months prior to the senior executives being aware of it and then making the disclosure. And so you have to figure out who in the organization is in the best position to make those kinds of materiality determinations and to be involved in the disclosure. And so you have to understand the experience at the management level, the experience at the board level, and make sure that you have controls in place so that that those types of incidents are reported all the way up and they can make the disclosures. And that might mean conducting tabletop exercises and making sure that everyone in that reporting chain understands how the process is going to work. And then the other thing I'll just highlight from the proposed rule, I think it's important to also consider controls and procedures around third-party information, because it's not just about your own information that you own, but also information systems that you use. And so you have to make sure that you have controls in place to account for those types of vulnerabilities and cyber incidents so that you can make sure you fulfill your disclosure obligations.
That's really helpful. So Dan, I want to leave some topic for clawback rules. So just, I don't know if you have like a 1-minute perspective on how companies are dealing with figuring out what happened. There's a lot of cyber incidents that happen that aren't material, that could increase a company's risk profile going forward as it's designing controls. But any particular challenges that companies are facing in this area right now?
Yeah, look, I think the materiality analysis is very challenging. It's not easy to write a SAB 99 on a cyber incident. The new rule also talks about putting together related incidents. I think that's going to be a challenge. I think this is going to be a place where working with your auditors in a very direct way, documenting the analysis that you did, so you can demonstrate how you came out where you did is going to be the end, is going to be the analysis. It's an evolving area. There's a lot of emphasis placed on making this analysis as quick as you can after you've determined the incident. The reality of how these things unfold is you're never going to have all of the information right up front. And so I think it's going to have to be unlike an accounting case where you find a bad contract or you identify a misplaced decimal point. It's going to have to be an evolving analysis that occurs over the course of a period because of the 4-day requirement. And so I think that's going to be something new, and it's going to require some real close attention by chief accounting officers and just a constant vigilance and documenting that. It's going to be really important.
So turning to the clawback rules, which is the one area where we do have finalized rules. Carolyn, I'm gonna give this one to you. We've certainly seen a more aggressive stance on SOX 304 clawbacks, where executives who weren't charged in the underlying conduct are, they have imposed SOX 304 settlements imposed on them. And then you've got the new Dodd-Frank executive compensation rulemaking that just went into effect a few weeks ago, which makes this very timely. It applies to not just CEOs, but a whole litany of executives, and it doesn't even require a restatement in order for the clawback to be triggered. It could be a little R restatement, which I'd love Mike's perspective on in terms of unpacking that one for us. But before we get to Mike, Carolyn, really quickly, how's the division thinking about the old 304 clawback as well as the new Dodd-Frank clawback now that we're seeing it in its final form? Is it fertile ground for enforcement going forward?
Yeah, so just really quickly and at a very high level, if you're talking to us about 304 or about clawbacks, I think it's really helpful to go back to what the principle is behind that, and that's to incentivize executives to make sure that there are robust financial reporting controls and that there's the proper tone at the top. So I think it's good to have that principle in mind when talking to us about how we are applying 304 or what are the facts that we're looking for to try to determine if there's a clawback issue. And again, that you can see that manifest itself in discussions and the approach we're taking when it comes to no indemnification, for example, under D&O proceeds, looking at you said, at situations where the executives may not have been culpable themselves in the underlying misconduct. Issues like that, it's going to come back to that principle of it's trying to create the right culture and to have those incentives in place.
That's great. And Mike, what are the accounting errors that can trip up the new clawback provisions? Because it can get confusing.
Yeah, I feel like I'm on the clock here, so
Yeah.
I'll go quickly. Traditionally, it was what people would call a big R restatement, which means it's material to a prior year, and financial statements need to be reissued. The new rule also includes what people commonly call revisions, which is something that is not material to the prior year, but fixing it in the current year would be material. That, many people would say that's new, but that now comes under the scope of this rule in terms of triggering the rule. And then it distinguishes between a third category, which is an out-of-period adjustment, which is an adjustment you make in the current year that relates to a prior year, but it's not material to either the current year or the prior year. So the upshot for me is that materiality analyses are going to already get a lot of scrutiny, are going to continue to get more and more scrutiny. There's actually, I think, a warning in the rule that says something around, the manipulation of materiality analyses, and auditors and audit committee oversight is really important there. So we've talked, materiality has been a theme up here on all these rules, but I think on this issue, I think really there's going to be amped up scrutiny by auditors, audit committees, and of course, from the staff.
Great. Well, the accountant gets the last word, which rarely happens on these panels. So, this was a really great discussion. Thank you all to my esteemed panelists, and thanks to Bruce for organizing. Thank you.
Thank you. Great panel. Thank you, Anita. Well done.